Nudging origin. I don't know what that means. That's hello everyone in my mother's language, which is the Yaru language of the South West Kimberleys in Western Australia, the Yaru people. I'd like to pay my respects to the traditional owners here, the Djadjarong. I want to pay my respects to your elders, past and present. I'm late, and my apologies, and my EA is not to blame. I missed my plane. It's almost poetic, isn't it? I thought it might be useful if I could say a few things about constitutional recognition of Aboriginal and Torres Strait Islander peoples in the Australian Constitution and what's transpired thus far. I'm hoping not to go back to the conventions of the 1890s, but since 2010 perhaps. As you know, the idea of recognising Aboriginal people in the Constitution perhaps been around for a while, but really got impetus when Julia Gillard became Prime Minister and needed support from the Greens. I vote for the dark Greens myself, but part of the agreement was that there'd be a referendum on the recognition of Aboriginal and Torres Strait Islanders in our Constitution. Now, we Australians don't spend a lot of time around the barbie, or the esky for that matter, talking about our Constitution. Unlike some of our cousins in the Northern Hemisphere. You know, it's not a hot topic amongst us, and many of us don't know what it says. And prior to the establishment of the expert panel, there was after the establishment, of the expert panel, shortly after the establishment of the expert panel, there was a survey of Australians, just to illustrate my point, that we're not particularly interested in the Constitution, by the panel, that found that 54% of Australians didn't know we had a written Constitution, and I think it was 59%, don't quote me on the figures, but they were majorities, both figures. 59% thought that the Australian Constitution allowed us, or granted us, a right to bear arms. They were the folks who watch a lot of American TV. But anyway, a panel was established, an expert panel, and it was co-chaired by someone I'm closely related to. And they put out a report. There were some very eminent Australians on the panel. It wasn't top heavy with lawyers. It had people who had a different social life to lawyers. And it put out this report. And made a number of suggestions, put some propositions about changing the Constitution. I mean, the problem with our Constitution is that, firstly, it does not acknowledge that someone else had hold of this place before the British invaded, and doesn't recognise that fact. The fact of the matter is that the place was owned and occupied by other people. The British arrived and invaded the place, took it without consent of the natives. There was huge destruction of the original owners, both physically and to their societies. And that was wrong. And nothing's been done about that. And the constitutional recognition, because that's essentially is what we talk about as the unfinished business. The wrong not only hasn't been acknowledged, but it hasn't been addressed. It's part of the unfinished business, and the Constitution compounds the original wrong. So the expert panel thought things ought to be fixed, because unknown to many Australians, that particularly those who think we have a right to bear arms, the Constitution is a discriminatory constitution in two particular respects, one of which directly impacts on Indigenous Australia. Firstly, subsection 26 of section 51 is the so-called races power. That's the power that allows the federal government to pass special laws with respect to members of any race. I mean, putting aside the notion of race as being out of date and not very useful, but I think we know through our history what we're talking about when we refer to race. I think we're all the human race, but that's not very useful when humans are sometimes political beasts. In 1967, that was changed because the Commonwealth had the power to make special laws for the members of any race except Aboriginal natives of Australia. I forget the exact words, but what happened in 67, those except the natives, they're not the exact words, were deleted. So that gave the Commonwealth the power to make special laws for Aboriginal and Torres Strait Islander peoples. The problem with that is that law was, that section of the Constitution was implanted to essentially underpin the White Australia policy and to keep outsiders out. It was directed at non-Australians, if you like. That's why the Aboriginal natives were excluded from the operation of that section. And the intent of the section from the Founding Fathers was that this would give the Federal Parliament to keep the what were then called Asiatics and Negroes or coloureds out of the country, and if they were in the country, if they came into the country, there's laws that could regulate how they live their lives in this country. So it was never intended to apply to Aboriginal and Torres Strait Islanders. The other offending section is section 25 of the Constitution, which allows states to disenfranchise people, to outlaw, ban people from voting on the basis of race. And the Commonwealth can't do a thing about it. So that was okay 115 years ago, but I don't think today it's okay. Subsection 26 has been used in a racist and discriminatory way only in this country against Aboriginal people and Torres Strait Islanders. Because the unintended consequence of the 67 referendum, it gave the power to the federal parliament to make laws, special laws for Aboriginal and Torres Strait Islanders. Not only laws that were beneficial, but laws that weren't. And we've had many instances, unjust instances, of the federal government passing laws that discriminate, particularly against Aboriginal and only against Aboriginal and Torres Strait Islanders. Because that section was not meant to apply to Aboriginal people. But in 67, the electorate thought they were doing great things. Now, you know, there were Labor politicians and Liberal politicians, Menzies himself, Prime Minister, Don Chipp, and others who said don't do it. If you do anything, get rid of the whole section. And they understood what would happen, that it was open for the High Court to justify under that section laws of the Parliament that were discriminatory towards Aboriginal people, because that's what they were that section was meant to do. That was the work it had to do, was to discriminate against Asiatics and coloureds. The expert panel made a number of recommendations, including ditching both those sections, adding a new section 51A, which would have a recognition component to it and an operative component to it, a substantive component. They also suggested other things, prohibiting different forms of discrimination, including racial discrimination, in a new 116A, and there was a new 127, I think, that would recognise English as the national language and recognise that Aboriginal and Torres Strait Islanders languages have been around for a bit longer than the British have been here. Now, out of their report, which has really sat there in lots of respects, the Parliament set up a joint select committee on constitutional recognition. They've put out a report, that an interim report, and probably for the first time in the Australian Parliament, it's that committee is co-chaired by two Aboriginal parliamentarians, Senator Peris and Mr White from Western Australia. But they put out an interim report where they've made other suggestions to fill the space. And they've got a final report that's due at the end of next month to the Parliament, a select committee report. All of these suggestions involve differentiating Aboriginal and Torres Strait Islanders in the Constitution. And it might be a differentiation in a substantive sense or a symbolic sense. Banning racial discrimination is substantive. Recognising that Aboriginal and Torres Strait Islanders are here first is symbolic, to put it simplistically. And how are we going for time? Tell me to shut up. Now I have a problem with that, and it's born of knowledge of as a lawyer of how bloody difficult it is. It's almost impossible to change the Australian Constitution. I think we've had 46, correct me if I'm wrong, someone, but something in the mid-40s referenda, and I think 4 have succeeded, including 67 referendum, which had an over 90% yes vote on average. My state, Western Australia, trumped Queensland and had the lowest yes vote. And things haven't changed much over there, I must say. They're closing us down now. You've got to get a double majority. You don't just get a majority of voters, you've got to get a majority of states to say yes for it to succeed. And I think overwhelmingly people distrust particularly what politicians and urges say about constitutional change. And particularly if the constitutional amendment proposal is complex and wordy. It will not happen, believe me. And that's the problem with the expert panel's proposal. It's the problem with select committee's proposal. It's the problem with a lot of people, commentariat, who go around talking about other things like a declaration. If you're a student of constitutional change, wordiness does not cut it. And talking of cutting, constitutions tend to get through if the proposal is to cut something out, not put something in. So my proposal, which I confess is not an original proposal for me, it's a proposal I now share with my colleague Dr. Asmi Wood at the Australian National University. He's a lawyer as well, and he's a Torres Strait Islander. And we've had lots of discussions about this proposal. And given the politics around these things, not just in the broader community, but within Aboriginal, within the Aboriginal community, I don't think we've got Buckleys of getting through any of the proposals that have been put thus far, because they're too complex, they're too wordy, and they're too divisive. So the proposal is to actually not recognise Aboriginal and Torres Strait Islanders in the Constitution. The proposal would be to say to, the question would be to Australian electors, Australian voters, subsection 26 of the Constitution is to be deleted in its entirety. Do you agree, yes or no? Subsection 25 is to be deleted in its entirety. Do you agree, yes or no? Now, we can fine-tune that question a bit more than the way I've put it. I haven't given a lot of thought to it, but I've given a lot of thought to deleting those two sections and doing nothing else. Just get rid of those sections and do nothing else. Now, I started off talking about differentiation. Immediately you mention race in the Constitution, and you mention Aboriginal and Torres Strait Islanders in the Constitution. You differentiate those citizens from the rest of the citizens. And our argument is, well, why the differentiation? That's the differentiation, even in the words that have been proposed by the Select Committee and by the expert panel, the differentiation is still there. And once you differentiate, you say these people are going to be treated differently than the rest of the citizens. There's huge problems with that in my thinking about this now. You know, I've previously supported with some qualification the expert panel's report and suggestions, and I've previously supported aspects of the Select Committee's report. I've never supported anything that Noel Pearson said about this. I support some of the things that Megan Davis says about this. I worry about what George Williams says about these things. I'm concerned about, these are constitutional lawyers you all know really well. You know, you talk about them around the barbecue. Or Anne Toomey, you know, and they're all lawyers who I have a great deal of respect for, but I think they're wrong. And the impact of ridding us of those racist and discriminatory sections of the Constitution will be to get rid of differentiation. So you might say, well, big deal, you know. How's that going to help anybody? Well, you've got to put trust in the court. Our democratic system, our constitutional arrangements have checks and balances in it. It has the Parliament, the Executive, the Court, you know, the High Court. And as far as the Constitution is concerned, I would be more confident having the Court look after it than the Parliament. And I think that's borne out through the history of constitutional change and and it's really bad scorecard. You know, even Mick Dodson hasn't got a losing score like that. So what that then says, and we're nearly there, what that then says is that, oh, there's no mention of Aborigines or Torres Strait Islanders in the Constitution. That must imply everybody's going to be treated equally. There's no mention of anybody being treated differentially. So, the people must mean that everybody has to be treated equally. And the High Court's nearly there. It's nearly there. And those two sections is what's stopping them from going all the way. Even this High Court, I think, could be persuaded by people, lawyers far more eloquent than me, and learned and know what they're talking about. But the impact of that would be, I think you could quite strongly argue that what Colin Barnett's trying to do with Indigenous communities in Western Australia is unconstitutional, because you're treating them unequally. You're not shutting down any white towns or villages. You're only targeting Aboriginal towns and villages. It would put paid to the Northern Territory intervention, because that's differential treatment, unequal treatment. It would have a profound impact. But, you know, the but is you're putting a lot of faith in the lawyers that make up the High Court. So this raises a lot of questions, and no doubt, rather than me raise them, I'll let you raise them. Thanks. You know, our right to be acknowledged is about equality. And what the Constitution gives you is formal equality. What the jurisprudence gives you is substantive equality. And you can argue for substantive equality. And I can see an argument being run around the non-recognition, and the High Court making a declaration about that, which is far better than the con-cons are saying about a declaration, which is an act of Parliament, which parliaments can undo. You know. Parliaments can undo High Court decisions about common law, but as far as the Constitution is concerned, the only way you can do that generally is by changing the Constitution. When you look at the... See, what happens if you get... This is my speculation, but it's not unfounded speculation. What happens when you get a right to equality is that you import the jurisprudence around the meaning of the right to equality. And much of that is international jurisprudence. And I wouldn't think it's too long a bow to draw to say, well, we can argue. We could put a case on the basis of equality of treatment for a treaty. I've worked for most of my professional career in the UN. I was involved in the not the whole 25 years, but the the substantive part of that time, 20 years of the 25, working in the UN with other Indigenous peoples from around the world, elaborating the United Nations Declaration, what's now the United Nations Declarations on the Rights of Indigenous People. One of the provisions of the Declaration is that states who endorse the Declaration should rearrange their constitutional legal arrangements to accommodate the Declaration. Australia hasn't done that. There are only 4 countries who voted against the resolution of the General Assembly to endorse the Declaration. They were Australia, Canada, United States and New Zealand. Now, since the adoption of the resolution endorsing the Declaration in 2007, September 2007, all 4 of those states now, including Australia, endorse the Declaration. It, I think, could very easily be brought into Australian constitutional jurisprudence by usage and reference. And remarkably, much of the substantive parts of the Declaration are already common practice in Australia. Well, the Declaration contains a whole range of things. I think there's huge potential. It's 46 articles. Each of them are dealing with this particular situation of Indigenous peoples worldwide, and generally about Indigenous peoples' positions worldwide. It deals with the right to self-determination, for example. It deals with equality and non-discrimination. I think if we'd got a constitution that says people have to be treated equally, I think it benefits all Australians, particularly women and children. I think it would give more meaning to the Convention on the Women's Convention, the Convention on Rights of Children, and the Declaration on the Rights of Indigenous People. Because what will happen is that we don't have to rely on primarily the international jurisprudence or as well the jurisprudence of common law nations. It sounds sort of contradictory, but the language of equality allows differentiation, and the jurisprudence of equality allows differentiation. It allows what's called special measures. It allows things like abstudy. It allows differential treatment in order to bring equality. You can have special programs for Aboriginal kids. So and the objective is to reduce the infant mortality rate or whatever, or for pregnant mothers, or all of these sorts of things you can do, and the government already does those sorts of things. but they'd be allowable under the principles of equality. Equality allows differentiation. And it's the same thing that happens with the Racial Discrimination Act here in Australia, is that things that might appear to be racially discriminatory because they're favouring Aboriginal workers or Aboriginal institutions or organisations, but they're allowed under the right of equality, because you're allowed to take special measures to bring people up to equality. This is the question about rogue states. And I've given this some thought. You'd have a third string to your bow if you had a implied right to equality in the Constitution. The first two strings are Section 109, which gives the Commonwealth power to make laws that will override rogue states. So, you know, if a state law is inconsistent with a Commonwealth law, the state law is invalid to the extent of the inconsistency. You have the Racial Discrimination Act, so you can rely on it not to challenge what Mr Barnett's seeking to do, because it's racist. He's not telling any non-Indigenous communities or towns or villages that he's going to close them down because they're unsustainable. So that's the inequality. It also brings in the equality argument. So I think the basis would be covered, and it also would have the implied right of equality and I haven't given this a lot of thought, and I need to think it through. I need to read a bit more about it, but I think that an Aboriginal person could go, like the Narranderi Hindmarsh Bridge case, could go to the court and say this is not just a breach of the Racial Discrimination Act, it's a breach of my right to be equally treated with respect to my spiritual beliefs, my religious traditions. But that's not there. See, what happened is that the court says, well, the Commonwealth can override the Racial Discrimination Act. And besides, subsection 26 doesn't have to be a law for the benefit. But 26 is gone. It will have the impact of knocking over some existing legislation, which is racist. But why the hell do we want to keep them?